The most common reason that a landlord property manager will begin the eviction process is because the tenant did not pay the rent when due. The first thing that is done to begin the eviction process is completed by providing the tenant with a written notice of default called a 5-day notice letter. In legal terms, that is also referred to as a forcible detainer. The full term of this letter is the 5-day notice of intent to evict, yet it will be referred to as the 5-day notice. The 5-day notice must tell the tenant that they are delinquent in paying the rent and state the amount of money the tenant must pay to bring their account current. The notice must also tell the tenant, in clear language, that the lease will terminate unless the tenant pays the entire amount due on or before the expiration of 5 days from the date the tenant receives the 5-day notice. The landlord/char's property manager may demand payment of an amount of money in the 5-day notice letter that includes the past due rent and any penalties or late charges that are stipulated in the lease between the landlord and the tenant. If the tenant pays all of the money demanded in the 5-day notice on or before the deadline for payment, the landlord property manager must accept those funds and continue the lease with no further penalty. If the tenant has committed some other type of material breach of the lease agreement, the landlord property manager can give the tenant a 10-day notice letter. This type of notice letter should clearly identify the breach of the lease and tell the tenant they must cure the breach within 10 days or the lease will terminate. If the tenant fails to cure the breach, the landlord property manager may file a special detainer lawsuit to evict the tenant. Such a breach might include the condition of the property, violation of the crime-free addendum to the lease, a tenant-created maintenance issue, etc. There are several ways to deliver the 5-day or the 10-day notice, and the landlord property manager should be extremely careful to deliver the notice properly because any court that hears a case for eviction will be looking for proof of proper delivery. The best way to deliver the notice is to hand it directly to the tenant. You may also deliver the notice to a person of suitable age, residing at or in charge of the leased premises. That person can be a minor under certain circumstances, yet handing the 5-day notice to the tenant's 5-year-old daughter would not be acceptable. Handing it to his 12-year-old daughter might be acceptable since it could be argued in front of a judge that a 12-year-old is competent to accept delivery. Since a tenant in default might be expecting delivery of the notice, it is acceptable to post the notice conspicuously on the front door of the residence if you also send the notice by certified mail to the tenant the same day you post the notice. While the landlord property manager can certainly hand deliver and or post the notice on the property, it is advisable to use a third-party process server who has experience in such matters. Such an entity will provide you with the detailed proof you need on the delivery of the notice. They would prepare a written statement that shows the name of the person to whom the server delivered the notice, the address, the date and time, and the signature of the server. The courts will readily accept notice of service in that form. The Arizona Residential Landlord and Tenant Act also allow the landlord property manager to deliver the 5-day notice by registered or certified mail. The law does not require that the certified mail be sent with a return receipt request, but the best practice is to send the tenant certified mail, return receipt requested. Since the tenant is probably avoiding other creditors, the person probably will refuse receipt of the letter and certainly will not go to the post office to retrieve it. Thus, when the landlord property manager sends the 5-day notice via registered or certified mail, the law provides that the tenant is deemed to have received the notice a few days after the notice was mailed. Be sure to document the mailing date of the letter. The best way is to prepare the envelope as a certified return receipt and bring it to the post office. The clerk will stamp the envelope and provide an official proof of mailing receipt that shows the date of mailing. That will be all you will need to show to the court for proof. If the tenant does not pay all money due after receiving the 5-day notice, or cure a material breach within 10 days of the notice, the landlord property manager may file a forcible detainer lawsuit in the appropriate court to evict the tenant and get a judgment for the amount owed. At this point, some landlords' property managers will only file for eviction, since they are unable to determine if the tenant has caused any damage. They would then need to sue the tenant after the eviction and after a new tenant has moved in. As the property manager, it is best to be sure that the tenant does not have any specific complaint regarding the property or the landlord's refusal to remedy a problem. That might include the refusal to keep the property habitable or some issue that affects the tenant's peaceful enjoyment of the premises. Do you need to hire an attorney to handle the eviction? No. Many landlord property managers who have experience with residential evictions do their own evictions. Plaintiffs typically file forcible detainer actions in an Arizona justice court. A landlord property manager who elects to file a forcible detainer action in justice court should file it in the justice court precinct where the property is located. If the filing is simply for eviction, then the justice court is the proper venue. The landlord property manager should name as defendants in the lawsuit everybody who signed the lease, everybody, adults over 18, known to reside at the residence. The complaint should ask for a writ of restitution, eviction, possession of the premises, all late rent, all late fees, rent due through the end of the current periodic rental period, and the landlord property manager's court costs. Court costs typically will be the court filing fee and the cost of a process server to serve the summons and complaint on the defendants. A landlord property manager who hires an attorney for the forcible detainer may add the attorney's fees to the amount of the judgment obtained against the tenant. Attach a copy of the lease agreement and the 5-day notice to the complaint. Generally, the court will set the forcible detainer trial 3 to 6 days after the filing of the complaint. The landlord property manager must have all the necessary paperwork and be ready and prepared to go on the trial date. The court clerk will issue to the landlord property manager stamped sealed copies of the summons and complaint. The landlord property manager must have the summons and complaint served on the tenant immediately. Serving of the summons and complaint in the proper fashion is the landlord property manager's responsibility. The law requires this to happen at least 2 days before the trial date. All justice courts have constables. One of the duties of a constable is to serve the process. However, constables have a number of other responsibilities, so they might cause a delay in the process. You might consider using a private process server to attempt personal service and at the same time send the summons via certified mail. Some process servers don't automatically send the alternative service by certified mail, so ask them about their policy when you hire them. The alternative service method also requires that the landlord property manager post the summons and complaint on the front door within 1 day of filing the complaint. If the tenant is avoiding service of process, using the alternative method of service will enable the landlord property manager to obtain a judgment when the trial date arrives, as long as the trial date is set at least 4 days after filing the complaint, and the alternative service occurs on the day of filing the complaint. Timing is critical here. If your process server succeeds in obtaining personal service on the tenant, he will file an affidavit of service with the court. If your process server cannot serve the tenant, he or she will file an affidavit of attempted service with the court. The landlord property manager must be able to prove to the court that the landlord property manager either personally served the tenant or that they attempted personal service without success and correctly served the tenant using the alternative method of service. This is important because if the landlord or property manager fails to serve the summons and complaint properly and timely, the court will not evict the tenant at the hearing. Tenants frequently contact their landlord property managers and attempt to reach a settlement of a rent dispute by paying less than the entire amount in arrears to entice the landlord property manager to allow them to remain in the residence. The landlord property manager is not obligated to accept a partial payment of the amount owed. A landlord property manager who accepts a partial payment waives the right to terminate the lease and waives the right to have the court evict the tenant for the breach of the lease,